Here are my 10 top tips to help you win any dispute. These are particularly relevant in court trials, whether that is a civil trial or a criminal trial, but they can also be applied in any area of your life to help you win a dispute where the facts really count and you want to make sure your point comes across. So grab a pen and paper and let's get going. But first of all, if you're new to me and my channel, I'm a barrister who helps you understand law. So make sure you hit that subscribe button so you don't miss out on any future videos. If you hit the bell icon, you'll get notified when my videos are released. And we do a live every Sunday at 10 AM answering your questions. And if I don't get around to your questions on the live chat, jump over to Black Belt Secrets for questions in the comments, which I do as often as I can, and I'll get around to your questions there. So let's on with the list. In 10th place, and as a logical place to start with a chronology and specific times, dates, and places. Be specific about where something happened, when something happened, even what time something happened. The best way to do this is take a photograph of something that's going to remind you of exactly when it was, where it was, because your photograph will have a timestamp on it. Even if you post a letter and you want to prove that that letter was posted at that time and place, make sure GPS is turned on your phone. Take a photograph of the letter as you're putting it in the post box. The photograph will have a GPS location of where you are, the date that the photograph was taken, and thus when the letter was posted, and even what time that letter was posted to. Because it's important, if you want to stick to dates, which I'm coming back to later, that it's posted before a certain time in the day to make sure that it's picked up by the post. Also, times and dates play an especially important role when putting a case together. Not only because certain things happen within a certain time frame, or you might have time limits, but in the extreme cases, you might have a limitation period, which means if you don't bring your claim within a certain limitation, your claim will be statute barred and your claim won't be able to progress. Unless, of course, where there are situations that time limit can be overridden. But otherwise, times and dates are especially important, so start with a chronology. When you're setting about your case to prove your point, set out a full list of chronology in as much detail as you can, being absolutely specific. If there are gaps in your chronology when you do it, there will be gaps in your chronology when you get to court or in your argument, and your argument is going to fall and stumble at that very point when you cannot be specific as to what happened on that date. Now, you will have picked up on the word specific. That brings us to number 9. Number 9 is be specific. If you cannot be absolutely specific, you can say on or around a certain date, but ideally you want to be able to say that it happened on that date. Particularly when you've got time references, deadlines, you want to be specific. But this doesn't just go for times and dates. If you want to describe what you saw, you need to say precisely what it was you saw. Not just that something was dark in color, but what color was it? Was it dark blue? Was it dark red? All of these things matter because the more specific you are, the more likely you are to win your argument based on a set of facts. It's also no use just saying there were lots of people there. Well, lots of people to you in different situations might mean something completely different to somebody else. Was it under 10 people? Was it between 10 and 20 people? If you know exactly how many people it was, say exactly this is how many people were there. If it was in the hundreds and you can't possibly know, then you can give an estimate to say there were hundreds of people there, and then you can be specific and say, I would equate that to the number of people that would be at, for example, might be a small theatre, might be a school hall. It will be more specific than just saying there were lots of people, because this doesn't necessarily mean anything to anybody. And generally, the more specific you are, the more credible your evidence is going to be. Let me give you an example. You have two people both saying that something happened on a given date. One person says to you, at 10:35 AM, I was at this precise location, and this is precisely what I saw. Person B says, I was there sometime in the morning, it was around town somewhere, and I saw something like a dark-coloured jacket on this person. Obviously, both might well be telling the truth, but you are much more likely to find person A credible because they are being specific. Now, I'm not saying to you make up details so that it sounds specific. What I'm saying is be specific as to every single detail that you can recall. This is where photographic evidence is absolutely useful. If you want to be specific about something, take a photograph, take a film, jot it down, write it down. All of these things can aid your memory and make it more specific for recall later on. Now, talking about supporting things with evidence, that brings us to number 8. Support the facts that you say with evidence. Again, if you've got the same two people, one person saying it was 10 o'clock in that morning, the second person says, no, actually it was closer to 12 o'clock that morning. Again, if you've got evidence, such as a photograph or anything else that proves that it was 10 o'clock, clearly you're going to win that argument because you have some evidence to support the fact that you are saying. Even if the only thing you have is a written contemporaneous note of what happened, contemporaneous being created at or around the time of the event itself. Even if that's the only thing you have, you can produce this note and say to the court, I know that this is what happened because I made a note of it, and here's what happened. I wrote it out in great detail. This supports my account of what happened as against somebody else's. But what if it's someone else that's given you this information and it's not your information in the first place? This brings us to tip number 7. Clarify where the information came from and attribute it to its source. That might be a person, that might be a document, it might be a video, it might be a photograph. Wherever this information came from, it will be much more reliable and in fact a requirement of the rules to say where you got this information from. When you write out a witness statement, at the very outset of this statement, you will say, I am making this witness statement from facts that are within my own knowledge, and if they are not from within my knowledge, I will attribute where that information came from. For example, if there was a conversation between two other people but not yourself, and you are giving testimony to what was said between those two people, as obvious as it might sound, you will need to say how it is that you know what was said between those two people. Maybe very simply, your friend told you the contents of that conversation. But again, apply all of my other tips to this. Be specific and put it in the chronology. When were you told? How were you told? Because after all, if it was not your conversation, you will need to attribute that knowledge to someone or something. It may very well be that you saw a video, perhaps on CCTV, of what was said between these two parties. If that's the case, that is where you attribute your information to, because you were not party to the conversation. But it is necessary to say where that information came from. And that also covers off some of the other tips, such as supporting it with evidence and being specific and slotting it into a chronology. Now, talking about being very clear about what it is that you are saying, many of you have been so kind as to compliment my videos on giving you a clear explanation on how things work. So for that, I'm very grateful. That brings us to number 6, which is use plain language. Just say something exactly how you mean it. Don't try to use complex words, or definitely don't try to use jargon where it's not necessary, because if you say exactly what you mean, then other people will understand exactly what you mean. Sometimes there is a very specific word that may not be within everyone's vocabulary that means a very specific thing that we may very well want to use. But that's not necessary when you are providing evidence and you just want to get your information and your story across as clearly as possible. So again, tip number 6 is just use plain language and say exactly what you mean and what you're trying to say, and other people will understand it, I promise you. But speaking of formalities, tip number 5 is read any court order very, very carefully. And read it more than once, carefully, and then read it again. And I'll tell you why. Many court orders will have something at the tail end of it that says, if you don't comply with this order, the court may strike out your claim, or they might strike out your case, or any of those kind of things. And what that means is if you don't do precisely what the order says by the date that you're required to do it, in the format or on the form and to the address that you're supposed to do it and send it, then your claim may be struck out, or your defense may be struck out. Struck out means it's no longer valid, it is no longer a claim, or it is no longer a defense. Or if it's your witness statement and it's not filed by a given date, then it's no longer a witness statement. But if you haven't filed it, then your whole claim or your whole defense may be completely struck out. So again, number 5 is read the order carefully, line by line, and if you don't understand it, then you absolutely must go and see a lawyer so the lawyer can explain, this is what the order means, this is what you need to do. It's quite easy these days to find a public access barrister to have half an hour just to chat through what a court order means and to find out, well, what does this mean? What do I have to do? When do I have to do it by? And why is it necessary? So if there's one thing you should pull out from tip number 5, reading the order carefully, that is deadlines. That brings us to tip number 4. You absolutely must stick to court deadlines. Absolute must. Because again, as I said in tip number 5, If you don't stick to those deadlines, the court may strike out your claim or strike out your defence. Because the courts deal with hundreds of thousands of cases every single year, and certain things must happen in a very specific order at a very specific time so that the whole thing is managed effectively, both cost effectively and time effectively. And if those things don't happen, the court simply does not have the time to chase people around to pick these things up and stick to those deadlines. Sometimes, but not always, if you've missed a deadline, the court may send a letter out to you reminding you that you need to file this thing by this date. But most likely what will happen in that scenario is that will be what we call an unless order. Unless you file this thing within the next 7 days, your claim or your defence or whatever it is struck out. So again, tip number 4 is stick to deadlines. And as a final warning with deadlines, if you miss deadlines, then you may very well have cost consequences against you. That means you might have to pay the costs of the other party if the hearing is not effective because you haven't filed something by a given deadline. Down to tip number 3, we get into fairly hot tips now. Tip number 3 is no opinions. Leave these for the experts. When you get to court, if you think about my early tips about the facts, supporting evidence, chronology, when things happened, being specific, sticking to deadlines, attributing the source of information, all of these sorts of things, your opinions, with respect, absolutely don't count. Unless, of course, the court asks you for your opinion, which is unlikely. Opinions are useful in cases at some point or another, but they are usually what we call an expert opinion. It's either from a single joint expert, that means one expert that both parties have agreed upon. In other words, the expert is providing their expert opinion on a very specific issue for the case as a whole. Not just for you and not just for the other side. They are telling the court, I've looked at all these facts and I think this was too big, too small, too wide, or who was at fault, or anything like that. That's what an expert opinion is likely to do. Sometimes there might be 2 experts, one instructed by you, one instructed by the other side, and they will have a conversation and try to agree a joint opinion. If they can't agree, then very rarely there'll be a 3rd expert brought in to decide between them. So once again, tip number 3 on winning disputes is leave your opinions out and stick to the facts. Unless, of course, your opinion really affects a specific fact or the court has requested your opinion on a very specific issue. Tip number 2 is not too dissimilar, which is no emotions. Leave your emotions out of the equation, with very few exceptions, which I'll come back to in a moment. But as a broad rule, leave your emotions at the door, because if you get angry about something, or you just get emotional about something, or worse still, you get sarcastic or critical about something, all of this may very well affect your credibility when giving evidence. Now, I'm not saying that the court won't understand if you get upset about something, perhaps whilst giving evidence. That's perfectly understandable. But what I will say is that getting upset about something is not necessarily going to help your evidence, because ultimately the court is trying to decide what happened. The court is trying to make a determination of fact. And by court, I also mean the jury, because the jury form part of the overall court process. And in a criminal trial at the Crown Court, it is the jury that is making a determination of fact. The judge is there to make determinations of law. Now, I did say there are some exceptions, and you will usually be told as to what these exceptions are, either by the judge if you're by yourself, or by your lawyer if you're represented. One such example is if you are the victim of a robbery or attempted robbery, because one of the elements of this offence is fear. If you are put into a state of fear by someone who is robbing or attempting to rob you, then this is going to play part of your evidence. So there are some exceptions where your emotions will come into play. But again, it's not expressing your emotion in court that counts. It is recounting how you felt at that time. If you were in fear of violence, then the fear of violence becomes a fact of the story. It is not an emotion that you portray in court, but you are referencing your emotions in your storyline. And finally, the one you've been waiting for, my number 1 absolute crucial tip is be polite at all times to every person. And that includes your opponent, not just the judge and the jury and the usher and the court clerk and other witnesses, but including your opponent as well. If you come across as rude or disingenuous, this is likely to impact on the credibility of your evidence as a whole. And it's the credibility of your evidence as a whole that you rely on to prove and win your dispute. And as a bonus side note for any aspiring barrister or solicitor, whether this is to support you in an interview or whether it's your first days in court. Again, being polite in this number one tip is going to help you, because if you are helpful even to your opponent, then you will come across to the judge as a very helpful advocate, and judges like helpful advocates. Juries like helpful advocates. And there is certainly nothing to gain from being unhelpful. So again, my number one tip is be polite and be helpful at all times. So I hope you found those tips useful. Drop me a comment below. Which one did you find the most interesting? Which ones have you used before? And don't forget to jump over to Black Belt Secrets for questions in the comments coming soon. Thanks for watching, and I'll see you next time.